Thank you, and good afternoon. My name is Jens Peter Schmidt, and I'm a partner in Mayer Brown's Brussels office and co-leader of the firm's European Antitrust and Competition team. Joining me today as co-presenter is Julian Allison. Julian is also a partner here in the Brussels office and a member of the firm's Antitrust and Competition practice. We both advise on merger control issues and were involved in numerous transactions and notifications worldwide. Before we begin, I would like to encourage you to ask questions by using the Q&A panel on the right side of your screen. We will make every effort to answer them at some point during the presentation. However, if we are unable to answer your questions during the presentation, we will follow up with you directly after the webinar has ended. With that, let's get started. Good. Today we will focus on 4 key topics regarding antitrust compliance and merger control: data room organization and access, confidentiality provisions and restrictions, deal documentation, and integration planning. I should note that we focus on issues that arise typically when competitors do a deal, and therefore please keep this in mind in this presentation. Some general principles. From an antitrust perspective, the parties must compete effectively up until completion. The pure intention to do a deal or even signing the sale purchase agreement or any other agreement doesn't change that fundamental requirement. So if the transaction aborts, the parties must have preserved their ability to compete effectively in the market. That requires that purchaser employees and executives are not contaminated by target information that they have had access to. Data room organization and access, we say it is as much a commercial issue as antitrust issues. From a commercial perspective, the seller will have a business motivation to protect its position in case the deal doesn't proceed. At the same time, however, the seller wishes or will wish to reduce its liabilities under any reps and warranties and indemnities by making a full informational disclosure. And there's sometimes, of course, a bit of a game, because also the purchaser in practice will have considerable leverage over data room access issues. He would say, hey, I'm not going to pay the price without more information. I'm not going to buy a pick and a poke. This, of course, maybe is very case specific and may be different in case of an auction where there are multiple of purchasers and the seller may be in a better negotiation position. Anyway, the key message here is that data room access and compliance is a mix of commercial and antitrust concerns, and that it is key to combine the corporate expertise, which we'll talk about in a minute, and antitrust expertise together. And the advice that follows now reflects this mix of corporate and antitrust expertise. Let us talk about some specific issues regarding the organization of a data room. It is standard practice to divide data into different categories of sensitivity in a data room. And there's no specific scientific approach to the categorization, but the following to us would be a commonly adopted approach. First, non-sensitive commercial information. This is general or aggregated or even historic known data, historic in the meaning of at least 12 months old and or already in the public domain. Second, we have commercially sensitive information, sometimes named with CSI, and this will be sufficiently current and precise data which, if disclosed, would be capable of distorting competition in the market. And third, we have so-called highly sensitive, commercially sensitive information, highly sensitive CSI, and the disclosure of such information would inevitably risk a serious distortion of competition. This category would typically comprise short-term, forward, or backward-looking price-sensitive data. Examples in a table will be shown later. And again, this division here addresses both commercial and antitrust requirements because, of course, also from a commercial perspective, the seller has no interest to offer insight into highly commercial data to a party he doesn't know whether it really has the intention to do a deal or not. Data room access is typically controlled in a number of ways. So normally we have data room providers, third-party vendors with technology know-how to control, monitor access to the specific categories of data. Second, the access is regularly limited to individuals nominated as members of a defined deal team. The access is normally password protected, and the data room information is made subject to confidentiality protection set out in specific non-disclosure agreements, NDA, and we talk about NDAs in a second. Importantly, and taking also into account the principle of proportionality in antitrust, or the question of whether there are less restrictive means, the disclosure of data room data is often made subject to a timing cascade, with sensitive data only being released later in the deal process when there's a greater deal certainty, a greater likelihood of signing and closure of the deal. As noted, data room access is typically limited to a defined deal team. And there's a general antitrust principle that individuals that have access to competitors' confidential information should not be engaged in competing day-to-day market-oriented activities. And why is that? Because if, say, a sales manager of a purchaser knows exactly the future prices of its competitor, it is very likely that such knowledge will influence the price setting and potentially soften or eliminate the competitive pressure. Individuals are considered clean if they are drawn from non-market oriented areas of the purchaser business. So, access to commercially sensitive information is typically limited to the clean team. But the access to highly sensitive, commercially sensitive information is typically limited to outside professionals, law firms, accountancies, economic consultancies, who are authorized to make a non-confidential summary for the clean team. And again, these refinements reflect antitrust requirements because on the one hand, but they also reflect commercial requirements on the other hand, protecting the target's confidential information, in particular if the deal fails. Here's the table that we have provided to try to categorize the various data. You will see non-sensitive commercial information on the left hand, the commercial sensitive information in the middle column, and the highly sensitive information in the right column. Again, there's no scientific approach. It's highly case-specific, for example, dependent on the industry, the concentration in that industry, etc., etc. Deals typically start with a standard non-disclosure agreement, and we give here some elements that you will find typically in a standard NDA. And again, if you look at the third bullet, where it says that, the second bullet, where the limitation is upon disclosure to those with a need-to-know basis, is quite standard and important because it again addresses the principle of proportionality and whether there are less restrictive means available. There's one point I would like to address here in that context, which is the challenge to report the information or the result to senior management. Because what is the deal team doing? Well, it undertakes due diligence in relation to the target and will be expected to address, for example, deal problems, risks, synergies, cost savings, and so forth. And the clean team will have access to all this information in the data room, but the senior management of the purchaser normally not. That means that reporting in detail to senior management potentially risks the breach of the NDA. And let me make some comments here. In practice, the issue of briefing senior management is often further complicated by subsequent imposition of higher levels of confidentiality than initially provided in the NDA. And those higher levels are often set out in separate confidentiality agreements, so-called CTCA, Clean Team Confidentiality Agreements. And those often provide for contractual freezes on any clean team member who has accessed the target information from being involved in overlapping target business for a period of 6 to 12 months if the deal breaks. So from a purchaser perspective, those agreements need to be watched very carefully because they risk freezing out key members of the purchaser's clean team from their normal day-to-day activities in the event the deal fails. So therefore, in practice, you cannot extend the clean team to cover senior management, as this would eliminate them from their senior position for the freeze-out period. Next, if there is an obligation that the seller reviews the summary done by the clean team in order to show it to the senior management, then you risk a continuous disclosure of your negotiating position. Therefore, here it is essential that any confidentiality desensitizing in relation to the CTCA is undertaken by the purchaser's outside counsel and not the seller's counsel. Finally, on this point, we think that the purchaser is well placed to negotiate down the terms of the confidentiality approach upon the basis that without an adequate information flow, there cannot be a best offer done or ultimately strike a deal. So let me turn now the presentation over to Julian, who will talk about deal documentation and integration planning.
Thank you, Jens. Well, as you will know, all merger control systems routinely call for deal-related documentation. So we wanted here to touch on how to navigate that process in a compliant way and also in a strategic way. Of course, the rationale of calling for deal-related documentation is to test whether the merger case being put forward by the lawyers and the economists in the notifications is consistent with the party's own internal business view as expressed in internal board papers, business reports, strategic documents, a potentially wide range of internal documentation. We find it interesting to look at a model merger regime just to get a sense of where the requirements are going in terms of supporting documentation. And we've chosen the EU, partly because we know it well, but also because in an international sense, it is setting something of a benchmark and therefore is quite a good test case. So looking at the EU model, we're just going to quickly run through the requirements in terms of disclosing supporting documentation when you make a merger filing. And some of these are pretty unsurprising. You, of course, have to submit the transaction documents. That would be the sale and purchase agreement and offer document. Note that it must also have all of the related and supporting side agreements. The purchasers and targets report and accounts, again, I think predictable. It then starts to become more interesting and we begin to get into the width and breadth of the net, if you like. You have to submit copies of documents prepared by or for any board member or reviewed by any board member or the shareholders. Board is actually defined quite widely, but this is the first important catch-all. So documents prepared by or for board members or reviewed by board members or the shareholders. What sort of things are at play here? Well, minutes of meetings where the transaction was discussed, analyses, reports, slides, presentations, analyzing or assessing the transaction with respect to, and then we get a list of market type issues, starting with the rationale for the deal, but then moving into market shares, competitive conditions, competitors, growth and expansion, and general market conditions. And then we get into another category, which is even more noteworthy, and this is a requirement to produce any analyses, reports, slides, surveys, and similar documents in the last 2 years which assess any of the affected markets. This is a different approach. These are not documents looking at the transaction. These are documents looking at the markets in which the transaction is taking place. And note that under the EU approach, this particular request can go back 2 years. And what they're trying to do here is to pick up documentation that has been prepared at a time where the parties weren't in a merger process and where potentially people were not being very, very careful about what they were saying. Again, we come back into a similar list of market-type issues. The technical word here is affected markets. What they're looking for is markets where the purchaser and the target actually overlap, either in a horizontal sense or in a vertical sense. But I think the noteworthy points here are they're looking for documents looking at the markets, the subject of the merger, and they're going to go back as much as 2 years, so potentially to a time when nobody had any idea that they might actually be going to do a deal. Of course, as you will be aware, when mergers go into an in-depth second phase investigation, whether that be in the US or in the EU, at that point, of course, the authority starts to extend this request for supporting documentation to an almost limitless degree, and both in the US and in the EU, for example, the process almost becomes open-ended with very, very extensive requests and almost cartel-style inquiries. Why are we talking about deal documentation? I think the question we want to ask ourselves is deal documentation and what can go wrong. And at the bottom of this slide, we really state what is, in a sense, a kind of classic potential disaster in merger control, which is where there is a clear conflict between the very clever advocacy in support of the merger and expressed in the merger notification and the submissions, which, as you will be aware, is inevitably these days a combination of law and economics, where there is a conflict between that type of work and advocacy and the company's own internal records. That, I think, is the classic thing that can go wrong in this area. And internal documents of the wrong sort will, of course, first of all, potentially undermine the stated rationale for the merger. They may, example, point to, and I'm just giving examples, greater market share, perhaps greater market discipline, perhaps increased margin. There are many euphemisms that are used in these types of wrong internal business documents to point to a potential anti-competitive result. And of course, merger control authorities jump onto these documents and cling onto them. Equally, the internal documents can also have a heavy influence on other aspects of the case, and we're thinking here in particular of market definition. One of the very first things that will happen when you try and set out who you compete with, who are your closest competitors, a very early response by regulators is to call for the internal documents and actually to interrogate those and to see, which rivals do the internal documents identify and monitor, what products and services are seen as substitutes, what geographic areas are looked at, why are certain competitors discounted, and what type of market shares have been estimated. So I think we perhaps highlighted the problem. I hope we've shown through the EU model the sort of extensive net that is now being required in terms of supporting documentation and how that can go back in time. So I think the next obvious question is, what can you do about it? What would be a recommended best practice? We have one proposal. Of course, there could be many. It's based on an experience with a particular client who is a very experienced and very frequent merger notifier. And we thought we would just finish this section with a very brief run through their particular approach, which we think is interesting. So firstly, there is a total control over the channels and media of deal documentation. And in fact, what takes place is a reliance on a particular approach, which is always to use a slide pack. and that slide pack is always prepared in draft form by the clean team. They don't produce other types of paper, whether it's emails or internal reports or other reporting media. The draft slide pack is always passed by outside counsel for checking and clearance in a legally privileged manner. An outside counsel is going to really check on two things. First of all, compliance with the non-disclosure obligations, whether those are set out in the NDA or that higher level of care, the clean team confidentiality agreement that Jens was referring to. So that's one task. And the second task that outside counsel will perform is to try and make sure that the slide pack doesn't cut across any actual or possible future lines of substantive argument in support of the merger, which of course will be going into the merger notifications and the submissions. Again, discipline in terms of other things being created, but no non-deal related market studies or analyses will be created. And as the deal progresses, the slide pack is continuously updated and refined and always subject to the same outside scrutiny. As I say, that's one example of potentially many, but we thought it was interesting and worth sharing. The final topic that we want to cover today is integration planning compliance. And what are we looking at here? Of course, between exchange and closing in relation to a transaction, there is a lot that needs to be undertaken. And one of those activities is to prepare to combine the two businesses, including very often preparing to take the steps that are necessary to achieve important synergies and cost reductions. Another important activity will be to take steps to introduce the deal to clients and to try and elicit support and understanding of the merger from the client base. And indeed, there could be other activities such as restructuring, or if the transaction is leveraged, there'll be a need to prepare a very detailed business plan. But we wanted to focus on this period between exchange and closing and on the activities that need to be planned and how that fits with antitrust law, and in particular the requirement not to lose competition in the market and also not to breach merger control by gun jumping. So let's just take a look at integration planning a little bit more closely, and on this slide 22 we'll take a little look at classic types of operational issue which are usually aimed at achieving synergies and cost savings. And what we put here is purely for illustration, but it could be that you're looking to take out or rationalize production capacity and utilization. There could be plans and timetables for capacity closures. You, of course, will have liabilities and costs in association with plant closures. It could be environmental cleanup. It could be input supplies or redundancies. You'd be looking to transfer input supplies to remaining plants. I think probably the picture is obvious. You know, when you get into this type of cost-saving, synergy, operational type integration, there are a whole range of issues, operational, flowing through into back office, administration, HR, R&D, and so on. And as I said in the introduction, of course, integration planning may also need to address other issues. They could be legal. A joint business plan where it's a leveraged transaction, very important. There could be a need to restructure the merged group. And of course, if it's a type of business which is dependent on a successful transfer of contracts, there could be a very particular need to visit potential customers and get them comfortable. Again, as I said at the outset, I think there are two particular areas of competition law to keep an eye on here. One is the general requirement that Jens explained, that of course the businesses must compete and be seen to be competing until such time as the transaction has closed. And the other bit of competition law that needs to be watched, which is more technical, is that the parties do not pre-implement the merger as a result of their integration activities. In relation to the first, which is a basic loss of competition in the market, you're into cartel-type territory, and of course you'll be aware that there are severe civil and criminal penalties in that area. In relation to gun jumping or implementing a merger ahead of formal clearance, these days there are substantial fines in a number of jurisdictions, and we've set them out very briefly just as an illustration. I mean, the EU, without doubt, takes the prize here with, at the moment, a threshold of 20 million euros in cases where there were no competition issues. So pretty severe in the EU, but certainly a trend elsewhere for that type of gun jumping to be dealt with pretty severely. I'm going to, if I may, just jump over the next slide. We were touching on whether you can carve out a part of a transaction and complete the rest. The very short answer is that's unworkable in most jurisdictions. But if I may, I'm going to just go on to some of the formalities for integration planning. And the reason for doing that is as follows. I think we've identified that when you're merging two businesses, there are a range of important integration issues that need to be addressed, certainly to achieve or be ready to achieve the cost savings and synergies. I think we've also identified that at the same time, it's very important that the businesses continue to compete effectively and are seen to compete, both in order to comply with general competition law requirements and also to make sure that there's no breach of the merger control requirements, which of course say that you must not implement the merger ahead of the formal clearance. So we then get into a question of how can you navigate this this issue, and we have here a number of recommendations. First of all, formalities for integration planning. As with so much of compliance, what we believe is needed is a process. So we would recommend that all integration planning meetings follow agreed formalities, and these will perhaps be unsurprising: agendas and minutes recording the purpose of the meeting, what was discussed and agreed, and the agendas and minutes to be approved ideally by external counsel. Clearly what's going on here is creating a paper trail which is to a very large extent defensive in case ever needed. When you're looking at the contents of the agendas and minutes, important that follow-up actions do not extend to measures which would wholly or partially implement the transaction or which might impact the party's actual conduct in the market. Now, a part of integration planning, and we touched on this a moment ago, will certainly be to present the transaction to customers and suppliers of the target in advance of completion. We think this is a necessary part of the merger process. Of course, third parties potentially have very substantial influence on the regulatory view of the transaction. We certainly think that it's a legitimate process to explain and present the transaction to key customers and suppliers. At the same time, from a compliance perspective, we think it's important that this process is carefully controlled, and here we would recommend draft speaking notes for such meetings to be prepared in advance and approved by counsel, and also that a minute of any such meeting is prepared and again approved. Normally, we would recommend that any such presentation of the deal is undertaken individually by the parties. It can be both purchaser and seller, but as a general rule, separately. Can you undertake joint presentations? We would not categorically rule it out, but we would certainly emphasize that that's an area where you need to be very careful and you would need to take very specific advice. I think the obvious reason there is that if you're trying to always maintain an image in a presentation that the merger has not yet taken place, and if you're also trying to ensure that the parties can continue to compete without being contaminated, I think it follows fairly obviously that joint presentations of the merger immediately risk compromising those objectives. Just going back to, customer or supplier presentations can explain the background, the context, the commercial benefits of the transaction. We think all of that is quite legitimate. but they must at the same time avoid any express act or statement or implication that the two businesses have already merged. I think that follows fairly straightforwardly. It's sometimes asked whether in those types of lobbying or presentational meetings with customers, can you get into some sort of forward-looking transaction which might almost be said to buy their support. Again, we don't rule it out, but we think that process would need to be very carefully controlled. Of course, any type of offer, we would say, would have to be unilateral from the purchaser. It can be a conditional offer based on the transaction going ahead. But while I think it's not to be ruled out, it's clearly to be identified as an area where quite careful prior legal advice would be required. Just turning in this whole subject of integration planning and compliance with antitrust law, I think it's worth making a couple of points about the way you set up the integration planning teams. We certainly think that the people engaged in customer-facing marketing and sales roles are not the people to be put into the integration planning process. Equally, we think it's important that those who are involved in the integration planning are clearly identified, are coordinated under some sort of hierarchy or an integration leader, are given quite specific integration compliance advice, and that they are brought within the general confidentiality requirements of the transaction, whether that's a basic non-disclosure agreement and or the higher level for clean team confidentiality. So important that they're brought fully within the confidentiality ring. As I said a moment ago, clearly it's absolutely key that the parties must compete until closing, and in this context we've got one or two recommendations. Of course, the two businesses will need to be run entirely independently from each other and in full competition. That means that it's important that any statement or action which takes place pre-completion mustn't indicate something to the contrary, such as that the purchaser has already taken control or that the purchaser and target businesses are no longer in full competition. It's perhaps obvious, but there clearly are some absolute no-go areas, such as combined price lists or joint procurements, or even a refusal to quote separately in response to customer demand. Another aspect of this integration process is, and this period between exchange and completion, is to manage communications. Important that in any communication with the target staff that it is made clear that the communication is for consultation or informational purposes only, and that it is not in any sense contractually binding. Equally, I think it's important to control the nature of the language so that it doesn't inadvertently indicate or suggest or imply that somehow the transaction is bound to happen or has already happened or will lead to particularly advantageous commercial results, such as better margins, cost savings, etc., or that the two businesses have in fact already begun to operate as one. I think a final word in this section on integration planning and compliance, the whole process, how to structure it, the teams, the control of language. A final, I think, point to make at the end is, of course, it must be emphasized that legal advice and assistance is always available in this area, and there has to be a process where if something hasn't been covered, which is always likely, then then specific advice should be sought and obtained. We've come to the end of integration compliance, and I just wanted to finish actually with a final overall point on today's presentation: compliance in the area of merger control. And what we find increasingly is that, in fact, although we've talked about 4 separate topics, these are increasingly being wrapped up into a single set of compliance advice addressing data room organization and access, confidentiality, deal documentation management, and integration planning and compliance. And we believe with those 4 elements covered in a single practical bullet form document, you really are then in a position to give the companies and the merger process very substantial compliance security. We've come to the end of the formal presentation. I don't know if we've had any questions. I'm getting a negative. So, but if nothing has been answered at this point, if you would like to raise any questions, we would be very delighted to deal with them. And if you would email them to Pascal Rucker, that's Pascal, P-A-S-C-A-L-E, Rucker, R-U-C-K-E-R, and that's at the email prucker@mayerbrown.com, then we would be very happy indeed to deal with them. I think it just remains for myself and Jens to say thank you very much for your participation, and we wish you a very good day.